morning, Mr. Allen.
Good morning, my lady, my lords.
We should make it clear that we listed this for an oral hearing because, in our view, there are only two options. One is to dismiss the appeal, and the other is that you might sow such doubt in our mind as to whether it's Act Clare that we must make a reference. So it's dismiss or refer. And there's a subsidiary issue as to whether the Miller cases are disposed of by the decision in O'Brien or whether, in fact, they raise different.
I understand that entirely.
Yeah.
My lady, what I've done is write a speaking note because time is so short.
Well, you've got a lot more time than is normal for these applications.
I'm well aware. As you shall see in a moment, I'm thanking the court for that already as my first submission to it.
Yes.
My lady, I'm not remotely surprised to hear what you say, and nor will you be surprised to know that I aim to try and persuade you that a reference should be made. It may well be that there are parts of the speaking note that can be taken at great speed, but it's helpful to have it there so that I can push on as necessary. Can I just ask whether the court also has had a chance to see a written note from my friend and a written note from myself and our team? Ours was sent in yesterday and his was sent in the previous day.
Well, I'm afraid I saw the respondents before I saw yours.
That's as it should be, because that was the order in which they were written.
Yes, I mean, I've only just now seen yours.
Right, I see. Well, then I may need to take a little longer over that as well. I'm going to dive straight in, if I may, to the speaking note, not all of which I will read to you, but if I can just take you through. My lady, I must first express my thanks, as I do in the first paragraph, because I know this has caused inconvenience to some of the judges and certainly to the court in some respects. And I want to thank the registrar and all the judges for finding time for this. The second paragraph gives you the reference to the two judgments. I needn't read that out. The third reminds us that this has already gone to the European Court, and indeed that on the 6th of February 2016, after a long series of hearings, three hearings in the Supreme Court, one in the Court of Justice, yourself and Lord Hope finally concluded by saying, working out what this conclusion entails will not be without its difficulty. The case will be remitted to the tribunal for the determination of the amount of pension to which Mr. O'Brien is entitled under the regulations in accordance with this judgment. There were indeed difficulties. There were many issues. I don't need to go through all of them, but one, and the first one, which had never been notified in any defence on behalf of the MOJ in the previous 6 years, but was raised soon afterwards, was the so-called year 2000 point. And we open that point in paragraph 7, where the periods of service undertaken prior to the transposition date for the PTWD, the 7th of April, should be taken into account in calculating the pension to which they're entitled in consequence of the ruling of this court in 2013. General impact will be evident. For Mr. O'Brien, who worked as a part-time judge for 22 years before the 7th of April and only 5 years after, it is, frankly, devastating. If the Court of Appeal is correct, the Minister of Justice can lawfully ignore about 80% of his service to justice in calculating the pension payments he is to receive in accordance with the Supreme Court's last ruling. There are many other judges in similar situations. There are several hundred that we know of who are BJ clients, Brown Jacobson clients. There are other solicitors involved. We can't say exactly how many judges, but we think it's of the order of 500 whose cases have been stayed at present and who have some years of service. Few will have had as many years of service as Mr. O'Brien, but some years of service prior to the 7th of April 2000. And the Miller appeal concerns a different but related point that has been called the primary time limit point, and this concerns the question whether the primary time limit of 3 months for making a claim set out in Regulation 8 runs from the point of retirement of the judge at or after 65, or from the conclusion of any particular part-time post. Now, I just make a short correction, if I may. The information note about this case seems to suggest that Mr. O'Brien is a party to the Miller appeal. That's not correct. Mr. O'Brien's case was subject to an argument as to whether it was in time or not, and it wasn't lodged within 3 months of his 65th birthday, which is the date of his retirement. There was a question as to whether it was brought within the secondary time limit. The ET found for him, the EAT was against him, and the Court of Appeal many years ago upheld the ET's decision that his case was within the secondary time limit. So there's a small correction that's needed to the information.
So we should strike out Mr. O'Brien together with.
Exactly.
And say the Miller appellants contended.
Exactly so. There has been much litigation on secondary time limits. You don't need to know about that, but it is obviously right that that will need to be revisited, or the outcome of that may need to be revisited if the primary time limit commencement point is later than the Court of Appeal or the MOJ have argued and the Court of Appeal have held. The Court of Appeal have said, paragraph 11, that it's from the end of any particular post that a claim must be made. Now, we submit this is completely counterintuitive, because no full-time judge would then have an entitlement to any actual payment. That only arises when the two relevant statutes, to which we shall refer in a moment, are applied on full retirement at or over 65. You could say that's two conditions or one condition with two parts, and I'll show you the legislation in a moment. Indeed, it's submitted that not only is this counterintuitive, it is grossly unfair to loyal and committed servants of justice, who obviously would have had no wish to litigate with the state while sitting in any judicial capacity, just because they were moving from one post to another. I want to take a minute now to show the terms of the two pieces of legislation. They're in Authorities Bundle 3, the tabs 27 and 28. And if I can ask you to turn those up for a moment.
Could you just clarify for me, or remind me, in paragraph 11, first sentence, what really is meant by the end of a post?
I'll tell you exactly the way it's been run. So, for instance, you have an employment tribunal judge who's part-time, and at some date he says, I'm rather bored with employment law and I want to be an immigration judge. Actually, more commonly, he runs two posts at the same time, he or she, but then he gives up being an employment judge and continues as an immigration judge, or some the other way around. And what the MOJ have argued is that the terms, years of service as the employment judge simply don't count. In due course, when that judge retires from all posts at 65, he will only have his immigration service, if that's the last post he has, that is taken into account. And we say that is completely wrong and makes an absolute nonsense of the way that the legislation has worked. I'll show you that.
Is the employment judge a different post from the immigration judge?
Whether you use immigration or employment first doesn't matter. But
No, but I mean, is it, because I mean, within the new tribunal system, I wasn't aware that there were different posts. I mean, but the employment has always been a separate pillar.
Your Lordship is entirely right, and you have a particular knowledge of this area. But many of these cases deal with situations under the old system before the incorporation of the employment tribunal system.
So it is at a time.
So there may be complications. I mean, Ms. Krasnow may know as to whether this point's been taken under the new system, because she's done a lot of the sub-litigation of this, but I don't. But what I can tell you is that there are a whole series of cases where people have had different part-time posts. They've moved from one to the other. Sometimes they've moved from, and it's worked this way, that you've had a part-time employment judge he's become full-time, or she's become full-time, then in sight of 65, they've gone part-time, and they've been stuffed in relation to their part-time service. They have been told because they did not bring their claim at the point they went full-time, they will not get their part-time years taken into account in relation to their pension. We think it's shocking, but that's the position of the MOJ. It's also shocking in the sense of being surprising.
Well, I'm less concerned with, I mean, obviously that's you're entitled to that view, but what I'm concerned is the technicality of the thing, because under the new system, part of the whole idea was to provide for flexibility. And
I understand.
The reason why people stopped being employment judges.
Your Lordship is entirely.
Was because there wasn't the work, because they'd put up the fees. And so, and whereas there was a lot of work in immigration. So it was government policy to encourage them to move from one to the other.
What the focus has been on what the terms of the letter of appointment say. So if you say part-time employment judge, which will normally be fee-paid employment judge, you then become salaried employment judge. Your previous years of service, if you don't claim at that point, even though you're 53, you lose it.
Yeah. All right, well, we'll come to
there
that.
You are. That's the way it's worked so far. I'm not going to go into further detail of it. I'm sorry, my Lord.
On their argument, you have to bring your claim in the ET within 3 months of ceasing to hold appointment as, say, an employment judge, even if at that point in time you're well short of your retirement age.
Absolutely. Yeah. That's the argument that the MOJ has argued. And at a point at which you would not be entitled to a pension payment.
Yeah.
You would not be entitled to a pension payment because you're not 65 and you haven't retired. Now, the law that would apply, as it were, which is the base against which the comparison takes place, is in tabs 27 and 28. And if I can take you very quickly to it, there are 2 enactments that are relevant. Of course, there's later legislation, but these are the 2 enactments. If I can footnote and say it depends when you started in office, whether the JPA applies to you or the JPRA. I don't want to take time over that. If you will go to page 763, you'll see that the entitlement of the full-time circuit judge, to whom Mr. O'Brien compared himself, is in section 5. A circuit judge may, on the recommendation of the Lord Chancellor, be granted a pension, and then the conditionality is set out. If he retires after 15 years' service, and at the time of his retirement, he's attained the age of 65 years. I want you to just note, because I shall come back to this, if he retires after 15 years' service, it is not an issue that 15 years' service by a recorder can include periods of time before the transposition date, i.e., for that purpose, they acknowledge the time could be taken into account.
Well, that's the Petiti point, isn't it?
Exactly. Then over the page, you can see the rate of the pension in sub 2 at the top of the page. And sub 3 says that if you've only done 5 years, you get 6/40ths and so on. Can I take that as read and move on? The JPRA deals with it in slightly different words. It's page 806 in the next tab. And you'll see that the entitlement is in sub 2, and essentially it works out as being a 40th of their salary up to 50% after 20 years. And the fact that Section 2 applies to circuit judges can be found, I don't take you through it, from sections 1 and 6 and Schedule 1. Hopefully we can take that as read. Back to my note. I want you to take on board, please, that the Court of Appeal did not refer, even though they were taken to them, to the terms of the JPA and the JPRA at all in their judgment. And they drew no distinction and really did not get to grips with the fact that it was conceded that for the purposes of the JPA and the JPRA, as we have seen, periods of service prior to are taken into account for qualification purposes. 15. I've made this point. There are many such judges. And I've made the point at 16 already, the surprising fact that you had to make these claims even though you would not have had any entitlement to a present pension. And we say that's wrong for the simple reason that the discrimination in question continued up to the point at which they actually qualified for a pension because they had retired at or above the relevant age, for the reasons we've shown you in the legislation. And we make this point. You simply could not work out what the entitlement was until you knew what the legislation was that was in existence at the point of retirement. You could not know until you opened the law books and said, at retirement, does the JPA apply to me? And if so, how? Does the JPRA apply to me? And no. You could speculate on it. You could say how it might in the future apply, but you could never be certain as to how it applied until that point. Well, notwithstanding that, the Court of Appeal and the AT have been against me. The history of the two sets of proceedings to date and their connection. The history is set out in the notes. I don't open it now. The points were taken separately before the nominated employment judge. Now, I'm afraid I misspelled his name. It's a small second M, so apologies there. The MOJ says the answer to the year 2000 point will be dispositive of the primary time limit point in Miller. We don't entirely agree with that proposition because the court will also have to construe Regulation 8. And here I'd like you to turn it up for a moment. It's bundle 3 of the authorities at tab 30. And the page reference is 979. And this sets out both the primary and secondary time limits. And you'll see in 8.2, an ET shall not consider a complaint unless it's presented before the end of the period of 3 months, beginning with the date of the less favourable treatment to which the complaint relates, or where an act or a failure to act is part of a series of similar acts or failures comprising less favourable treatment or detriment, the last of them. And then 4, for the purposes of calculating the date of the less favourable treatment under paragraph 2, where a term in a contract is less favourable, the treatment shall be treated subject to paragraph B as taking place on each day of the period during which the term is less favourable. Where the application relies on Regulation 3 or 4, and we'll turn back to Regulations 3 or 4, it's on becoming part-time or returning to part-time, which will be in some cases in the Miller situation. The less favourable treatment shall be treated as occurring on and only on, in the case of 3, the first day on which the applicant worked under the new varied contract and so on. And then 5, importantly, in the absence of any evidence establishing the contrary, a person shall be taken for the purposes of paragraph 4C to decide not to act when he does an act inconsistent with doing the failed act.
Where are you now?
979, page 979, 8.
085.
Regulation 8.5. If it's not done such an inconsistent, when the period expires within which he might reasonably have been expected to have done the failed act, if it was to be done. It's broadly, therefore, construed as meaning that discrimination continues to the point at which it could be put right, if I can put it like that. I don't have much time to develop that at the moment. It is in our application for permission to appeal in the Miller papers. We recognise, paragraph 21, however, that there is a close connection between the 2 points. Lord Justice Lewison expressed the European connection between the 2 points in his judgment in this way. The issue on these appeals is whether the appellants were in time in submitting that, this is the Miller appeals, complaining of unlawful discrimination. That in turn depends on whether their pension rights were definitively acquired at the time of their service or only when they retired, which is a question of EU law. That's the way he put it. And essentially, the argument for the Ministry of Justice is that the acts of discrimination are completed at the period of service, even though the relevance of that period of service has to be considered at the point of retirement. That's the argument that was made. And that was why it was agreed that they should, if possible, be considered by the Court of Appeal at the same time during the arguments in June, July 2015 last year. However, the Court of Appeal was not able to provide enough time, and they had to be taken in 2 stages. After the Court of Appeal's judgment in O'Brien, the Miller claimants recognised the difficulties they would face in persuading the Court of Appeal to take a different route, and so chose to accept the offer from the MOJ not to pursue them in costs if they simply let the skeleton argument stand as the argument on the later hearing date. So there was no oral argument on these issues in Miller. The Miller claimants' freestanding point about the construction of application of 8 to their situations has not, however, been abandoned. It remains a second and separate string to their appeal. But I do absolutely accept, in answer to my lady's question at the beginning, that the answer to the European question will inform the answer to the Regulate question. Some very short preliminary points, which I hope I can take.
Sorry, I'm not quite sure what that means. There's a European question, which we've got to decide whether it's Act Clare or not.
Exactly.
Assuming we agree with the Court of Appeal on that, where does that leave?
Well, you still have to apply the regulation, but the question that will then arise is whether there is in some way under UK law, because the part-time workers,
domestic.
Exactly point, is how you approach the question of discrimination from the domestic point of view. That's why I say...
You're saying that would be an issue for us to decide whether to grant permission to appeal to this court.
It is part of the Miller appeal, and I recognise fully that it will be informed by what you conclude is European law
yes, but we're
on
not
the
at
issue.
that point to Europe. On any view.
No, the construction of Regulation 8 is not a point for Europe. Yeah. That's the neater way of answering my Lord's question.
Thank you.
Now, I just need to deal very shortly with this. I don't know if the court has seen, but the registrar... I'm so sorry.
I'm sorry to interrupt you, but it just to be quite clear. So the implication of what you're saying is that even if we, whatever view we take as to whether the EU point is Act Clare, we, in any event, have to decide whether your Article 8 interpretation point raises an arguable question of
exactly
law.
So, the regulation. But I readily accept that you can't properly approach that until you've disposed of the European angle. I readily accept that entirely. I think that's... I say that because there's no doubt at all my friend would want to deploy submissions about how it should be dealt with in the light of the European argument.
But are you saying you could still win on the Regulation 8 argument, even if you lose in the EU?
That is the submission that we have made, and I repeat it now, and we've set it out fully in our PTA application. I really don't have time to develop it, but yes, it's set out fully there.
So at this stage, you would be wanting us to grant PTA, make a reference, or grant PTA at any rate on the EU point, refer that point to Luxembourg, and what?
And put over the Regulation 8 point. You have 2 options about that. I mean, you don't need to make PTA. You can make the reference as a step in the PTA application, as you know. Yeah. The Supreme Court rules and practice direction anticipate that. And so that would be a way forward for you. Can I just get through the next page extremely quickly? Time. There is a question raised about time, about whether the O'Brien application for PTA was in time. The rules say you can't make an application for PTA until it's been refused by the court below. The practice direction says whether or not it's been dealt with by the court below, you've got to make it within 28 days of the order dismissing the appeal. Well, because of the dance around these two cases, that was simply not possible. And
we are very unlikely to refuse permission to appeal or refuse to make a reference on a point such as that.
Well,
My lady, we don't invite you to.
My Lord, my friend has been entirely generous about it and recognises that we tried between us to work through this in a sensible way. And I've noted that there. Then you'll see there's a reference to the documents, and I'll come back to our note in a moment. We formulated the core issue in paragraph 32, and we've suggested, as you'll see at the end of our speaking note, that this might be the question that you would ask, although there are different ways this can be formulated. And I anticipate that you might even have been thinking that the question put on the information note is a question that could quite properly be put to the court. No doubt the lawyers within the Supreme Court have formulated the question in the 3 lines on the issue. But the way we've put it, I'll read to you, is this. Where on his or her retirement, the extent of a worker's pension rights are determined by reference to periods of service, is the right to equal treatment pursuant to the PTWD in the provision of that pension to be determined solely by reference to the law at the time of the period of service or at the point of retirement. We submit that the legality of the unequal treatment of any period of service has to be addressed by reference to the law that applies at the point of retirement. And it is not correct, as Lord Justice Lewison held, that the legal situation in relation to pensions is definitively fixed on expiry of a period of service. You should know that the MOJ has argued this since the judgment of the Supreme Court in February 2013 in relation to the quantification, but it has always accepted that service prior to the 7th of April can be taken into account on retirement in order to found a claim to a pension. The references are there. I don't propose to open them, but they make it absolutely clear that it takes a twin-track approach to periods of service before the transposition date. In a neat, but we say erroneous submission, Mr. Kavanagh calls this hitting the ground running. Well, whether that's an accurate description of his submission or not, we say that it is illogical, and he cannot show you a single statement in any European law case which says that this is a different approach that has to be taken to quantification and qualification. We say that it's wrong because it doesn't accord with the principle of the future effects principle, the principle of European law called the future effects principle. The effect of that principle is that service is relevant for both purposes, and it is inconsistent to argue it's relevant for one but not the other basis. There cannot be the slightest doubt that the application of the FEP to the right to equal treatment to the PTWD is already well established. It's made clear in the 2 cases, Bruno and Pettini and O'Brien. And I want to ask you to open O'Brien, if I may, and I hope that this is in the corrected version, which will be on the shelves rather than, I think, on the top. The usher will tell you if I've got that wrong. You will see it in Authorities Bundle 2 at tab 18.
This is the ICR report.
This is the ICR report of the reference judgment in Mr. O'Brien's litigation. And if you can see it both in Advocate General Cocotte's opinion at page 530. Have I got that right? Paragraphs 14 to 16. Yes, so it starts at 529. Yeah. So the Latvian government took a point as the admissibility of the reference, since the majority of Mr. O'Brien's work as recorder and inspector, which is now claiming, took place before the entry into force of the directive, which extended the application of the PTW to the UK. Over the page, and then the dates of Mr. O'Brien's service are set out, and then the Latvian government considers that the two directives can be applied only to events occurring after the expiry of the transposition period, or at least since its entry into force. That was the submission the Latvian government said, and it wasn't qualified as to quantification and qualification, said only to those events. 16. In connection with the applicability ratione temporis, however, the court has already referred to the principle that new rules apply unless otherwise specifically provided immediately to the future effects of a situation which arose under the old rule. It is inferred that the calculation of the period of service required to qualify for a retirement pension is governed, including periods of employment during the directive entered into force. And then a reference to Bruno and Pettini. And of course, the Ministry of Justice have leapt on the word qualification and said, that's as far as you get it, Mr. O'Brien, it doesn't go any further. And we say, no. The court itself dealt with the matter in similar terms at page 544, paragraphs 22 through to 26, 24 through to 26. Can I invite you to read that to yourselves?
So 24 to 26.
24 to 26 on page 544, and frankly it's in near identical terms.
Yes.
It's not without significance that A.G. Cocotte was also the AG in the Paris case, to which I shall refer to you in my note in due course. So we say the existence of the principle and its application to the PTWD cannot be in dispute. The formulation of the principle for the PTWD purposes and indeed discrimination purposes is not, as Lord Justice Lewison said at paragraph 6, a loose one. Describing it in that way suggests it need not be applied. We point out this undermines it as a principle of European law, and note, as we say, that it was repeated in these two judgments, because that's exactly quoting what was said in Bruno, and then repeated by the Advocate General Cocotte in Paris. So what is in dispute is how it applies, and the qualification that the MOJ makes in relation to the calculation of pension benefits. We say, however, that the effect of the FEP in these cases is that from the 7th of April, the PTWB applies to all treatment of all periods of service by a part-time judge, whether before or after that date, and thus in the calculation of his or her pension entitlement, the part-time judge is entitled to a pension fully equal, though reduced pro rata temporis, to that granted to a full-time judge who has served over the same period. And we make 11 interconnected points. Some of them are a bit repetitious, but I'm afraid that's the way a speaking note goes sometimes. We say it's obvious that from any kind of a practical point of view, the full extent of the discrimination in the provision of a pension becomes finally clear at the point at which the legislation is applied. And so that is when the FEP ought naturally to be applied. we point out that in Bruno, the FEP was applied without qualification. That is not to say that it was applied saying you can't do it to quantification. It's a full answer to all these points made by the MOJ, the AT, and the Court of Appeal about Bruno, that it cannot be explained away without a reference to the CJEU, as neither the Advocate General nor the Court in that case drew the distinction that the MOJ make as to the reach of the FEP. I.e., they did not say this applies to qualification, but it will not apply to quantification. You will not find that sentence in those judgments. Likewise, the CJEU has affirmed the application of Bruno and O'Brien without the qualification for which the MOJ argue. In neither of those cases, and this is turning to the judgment of the Court of Appeal, was any of the Barber-related jurisprudence on which the MOJ has relied, and which the Court of Appeal and the AT found persuasive, even mentioned. So they didn't discuss the approach taken in the Barber line of authorities at all. And that's why we say the judge below was right to hold, see his judgment, that it does apply as we've argued. He saw the logic of the argument about Bruno and Pettini. Now, this is the next point we make, and this is developed in our note, is that we can show you cases under Directive 2000/78, which is the framework direction dealing with sexual orientation, age, disability, and so on, in which, when it has come to decisions about discrimination in pension provisions, it has been assumed that periods of service before the transposition date of that directive will be taken into account in considering whether or not there's been discrimination. I.e., the point has been assumed in our favour in Directive 2000/78 type cases. Yet further, we say the Advocate General's opinion in Paris is clearly and unequivocally in agreement with our submissions and rejects expressly the MOJ's submissions to the contrary, and that's set out in our note.
Not the MOJ's.
So, sorry?
Wasn't the MOJ in Paris?
No, I beg your pardon, the submissions of the GLD, the Government Legal Department. That should be corrected in Little Roman 7. I'm grateful to my friend. Yet further, the AG's opinion in Paris is clearly and unequivocally in agreement with our submissions, and rejects expressly the Government Legal Department submissions. 9, in none of the Barber-related jurisprudence on which the MOJ relies was there a consideration of the FEP. Rather, it was all concerned with ensuring that the ECJ's purposes in imposing a temporal limitation on its judgment that the equal pay principle in Article 119 of the Treaty of Rome applied to pensions. So it cannot be said that the point is act clear against us. Lastly, as a final Court of Appeal, you have an added obligation, as you know. Before turning shortly to the notes submitted yesterday, I want to outline why we say that the MOJ's and the Court of Appeal's reliance on the Barber and Tenova line is entirely misplaced. Now, this is set out in our application for PTA, but I just want to develop it shortly for about a minute and a half, well, about 5 minutes perhaps, before going to the other note. Returning to the principal argument deployed against us, which can be summarized as being that the legal effects of a period of service are exhausted insofar as it's referable to pensions when that period ends, and not when the pension is claimed and the amount referable to that period is either qualified or denied. The basis for the MOJ submission is a wholly different set of cases concerned with a quite different problem that arose because of an ambiguity in the Court of Justice judgment in its famous Barber case. And the later judgments that explained it were determined contra what the European Commission said was the reality of the situation in order to avoid financial disaster for pensions funds. The key facts of Barber can be shortly stated. The employer's pension scheme had a discriminatory pension age, and that was continued through on the redundancy situation. And the questions were referred to the court as to whether the difference in pension treatment was contrary to Article 119, the equal pay principle in the original treaty. A key point in the argument in Barber was that a council directive had seemed to permit this kind of discriminatory treatment, at least until it was progressively eliminated. This had given rise to a certain legitimate expectation that Article 119 did not apply. And because the ECJ was aware that employers, and I would add pension funds, might have been misled, it gave a judgment whose effect was limited ratione temporis. It was widely considered to be ambiguous as to what part of what pension schemes were covered by this limitation. If you'll turn, please, to Bundle 1 at tab 4, we can see at page 93. I need more water. How this was done, I set it all out in the box for you. But you can see that in paragraph 44, it said, or 43, in the light of those provisions, and that's a reference back to the directive that seemed to have misled employers and pension funds, the member states and the parties concerned were reasonably entitled that the article didn't apply. In those circumstances, overriding considerations of legal certainty preclude legal situations which have exhausted all their effects in the past from being called in question, where that might upset retroactively the financial balance of many contracted out pension schemes. And it was those italicized words that were then the subject of the later jurisprudence. And meanwhile...
But you presumably emphasise the first three words of paragraph 44.
The first three words are absolutely critical, yes, of course, but they have to be construed in context, as the submissions from the Commission made entirely clear. And the arguments became essentially, did it cover all work prior to the date of the Barber judgment? Did it cover pensions which had been commenced before that date, i.e. people had got pensions started before that date, or did it cover some other variation of it? The Commission pointed out, quite rightly, that the effect of the protocol would take about 30 or 40 years to work through if it covered all work done before that date. Because there would be people who would be suffering under the protocol right the way through. And that's why their submission was that to say that it covered all work was essentially against the reality of the situation. That was the submission that the Commission made. Now, we've set out some of the background notes to that on paragraphs 48, 4 through to 51. There were two key articles that were mentioned in the Advocate General's opinions later on, one from Professor Deirdre Curtin and the other from Professor Honeyball, and we've indicated those. Time doesn't permit me to take you through those, but if I can go to 53, as we've noted in the application for PTA, the Commission argued that the proper approach was quite different to that ultimately taken by the Court in this jurisprudence. We've set it all out in our PTA application. Its view was that applying 44 of the Barber judgment, there could be no exhaustion while the time at which the pensions were due to be paid had not yet been reached. They argued that any other approach did not accord with reality. And I'm just going to show you that. It's in their submissions in Neath.
Do you mean it argued?
I do. It being the Commission. Yes, I do. And there are various places it can be seen, but one place is in a case called Neath. We've set out all the jurisprudence in the next paragraph. It's Authorities Bundle 1. Tab 8. At page 243b. Pick it up actually at the foot of the previous page. This is in the report for the hearing, where the judge-rapporteur set out the competing arguments. According to the Commission, when the Court sought to limit the temporal effects, I'm picking it up at 8 at the foot of 242, it meant to exclude the possibility of reopening discussion in relation to pension payments, which had already been made. The effects which had to be exhausted were the pension payments. If, as in the present case, the pension had not begun to be paid, there could be no exhaustion. The Commission does not share the view that contributions and work before the 17th of May created legal rights and duties between the parties and therefore constituted legal situations which have exhausted all their effects in the past. That approach does not correspond to reality. Whilst it may be considered that a particular legal effect has been achieved once a contribution period has passed, since a certain prospective entitlement to pension has been built up, it seems contrary to common sense to say that the situation has exhausted all its effects as long as the major intended result, namely payment, has not materialized. Consequently, the Commission considers that the correct interpretation of Barber leads to the result that Article 119 must be regarded as directly effective in relation to a pension payable after the 17th of May, irrespective of the fact that most of the contributions on which it was based were made prior to that date. So that was the Commission's position. What happened, though, was that there was enormous pressure put to carry out financial investigations into the consequences of that approach. And in the light of that, the Commission changed its position. And the Commission said and pointed out that it had taken, it had carried out 2 financial reports. You can see this. We've set it out in our in our application in O'Brien. Just give you the page reference. Sorry, page 38.
Page?
Page 38 of the core bundle. The paragraph is. Where did I put it? They do it. Is this where they put it right? Yeah. And you'll see it in its submissions. Perhaps a better place to find it is in the Collarole report for the hearing, which is Authorities Bundle 1 at page 254.
It's page 271.
Exactly so.
Radical change.
At letter G. The Commission admits it's radically changed its view in relation to the position it took in parallel cases, including Neath. It seems to the Commission that when the Court referred to legal situations, it meant to exclude the possibility of reopening discussion in relation to pension payments which had already been made. The effects which it considered to be exhausted were the pension payments. The Commission did not think that contributions and work of scheme members prior to that were legal situations which had exhausted all their effects in the past. It seemed to it that since the point of paying contributions was to build up pensions rights, the intended effect of such contributions could not be considered to be realized until pension payments had been made. The Commission therefore took the view that a correct interpretation of Barber was that Article 119 must be regarded as directly effective in relation to a pension payable on or after the 17th of May, irrespective of the fact that most of the contributions on which it was based might have been intended to have been made prior to that date. And then if you go to F, the explanation is there. The Commission points out in adopting that position, it was aware that it implied serious financial consequences for funded pension schemes, but at that time it only had unverified estimates of the costs. The Commission was, nevertheless, very concerned about the financial and economic consequences of its interpretation, and therefore asked the Member States to furnish it with figures and information in that regard, and also asked a firm of consultants to examine the financial consequences. Notwithstanding some uncertainties arising from inadequate knowledge of certain factors, the Commission states, it seems clear from the information available that the financial and economic consequences of the interpretation of Barber which the Commission has adopted until now are enormous. When one bears in mind the concern expressed by the Court not to upset the financial balance of pension schemes, that result seems surprising. Therefore, come to the conclusion that it can hardly be right. The Court cannot have intended a result which risks bankrupting a number of employers and or pension funds with consequent negative effects for the economies of the member states. So that's why it changed its mind. Contra reality, but for every reason of economic practicality. And the Court then took the view that in the later judgments in turnover, took the view, as we've seen, that for the purposes of interpreting the Barber ratione temporis limitation, work done prior to the date of the temporal limitation could not be subject to Article 119 on the basis it ruled, consistent with its judgment in paragraph 44, that the effect of that was exhausted. And that's what has been played as the ace card by the MOJ against us. And our reply is that has to be seen entirely in the context of Barber and Article 119. And it is telling that it has never been referred to in the application of the FEP in any of these cases. And indeed, as I've said, and we'll show in the note, it's not been a problem in Paris or in other situations. Now, I need to go straight to the note because otherwise I won't have time to complete within, I think I said I was going to finish just at, was it 12:40, was it?
11:40.
11:40, I beg your pardon. My lady, can I, since we were going to ask you to put this to one side, add just this. You'll have seen there's been a dispute about what the Aclair doctrine, how it's to be applied. That's set out in the submissions below. I'm not taking time over that. It's now accepted. It's the Silphit approach. You've made many references and you know what you think the law is. It's now accepted. It is a Silphit test. So I leave that to one side and I move on. Our note, if I may. We refer to two bits of litigation. First of all, a case called Lessar, which is already in the bundle at bundle 2 at tab 22, and I want to just open that for a moment. Apparently on the bench is a better version of Lessar. The photocopy in the bundle, I think, omits paragraph numbers. Just stand up and tell them, can you?
My lady, it's on the bundle on your right, loose.
I've got it just completely loose.
Super, thank you.
In fact, I think you might be in a slightly better position than me because I'm not sure where I've put my copy.
Mine was just loose.
Could you get me a copy with paragraph numbers?
That's mine.
Bless you, John. That's really kind. Thank you. In fairness to the Court of Appeal, I did not refer to Lessar. I wasn't aware of it until after the arguments. I think I must have picked it up when it came into the All England's European Court reports. I didn't pick it up when it was published. You'll see the case concerned a question as to whether there had been unlawful age discrimination in the calculation and payment of a pension to Mr. Lessar, contrary to Directive 2000/78. My lady will know this. If I may say to the wing members, without lese majesty, Directive 2000/78 is a non-discrimination directive dealing with sexual orientation, age, disability, and so on in the employment field. and it uses a similar juridical approach to that you find in the Part-Time Workers Directive. Mr. Lessard was born on the 3rd of June 1949, retired on the 1st of September 2004 when he was just over 65. His retirement was after the date of transposition of the directive, and for a period before the 3rd of June 1967, when he was 18, he worked as an apprentice. During this period, as he did thereafter, he paid contributions to an insurance institution. However, when it came to claim his pension, these periods were not taken into account in calculating his entitlement. And of course, that took place after the date of transposition. And the court referred questions saying, was that unlawful age discrimination? And you can see the questions in the box in paragraph 7. The answer was that the Austrian legislation, excluding the counting of these early years of work, was prima facie directly discriminatory and therefore contrary to the directive. But the framework directive, permits justification of direct age discrimination. My lady will remember Selden. Yep. And they held that it was necessary for the Austrian party to justify, and in fact they did justify, essentially is what it came to. So the point about Lessard is it assumes the very argument I make, i.e. nobody took a point saying this is all irrelevant because the legal effect of the years of service back in the day when he was an apprentice have to be considered in the context of whether it was lawful to discriminate about its treatment then rather than now. The case was treated as being a relatively easy one to deal with. If you look at the box on page 5, paragraph 18, it followed a judgment called Falber to the same effect, and indeed before that another case called Hütter, which was an Austrian case also dealing with work under the age of 18. I haven't put Hütter in the bundle, but Falber is. I just read that paragraph. It should be noted at the outset, it's common ground that by excluding for the purpose of calculating such a retirement pension, some civil servants from the benefit of having the periods of apprenticeship and work completed before the age of 18 taken into account, the relevant Austrian legislation affects the conditions of pay of those civil servants within the meaning of Article 3.1, that's the definition of direct discrimination. Accordingly, the directive applies to situations such as that in the issue in the main proceedings. So it absolutely assumes the point in my favour. If you then, I don't think it's necessary to read all the justification that is dealt with in the rest of the box. But if I go on to paragraph 10 on the next page, this was not the first time that the court had taken this view. Falber, which is in the bundle now at, I think, tab 32, if you want to make a marginal note. And Falber itself refers to an earlier Austrian case called Hütter. If the MOJ's argument in O'Brien is correct, those periods would not be subject to non-discrimination law. Now Paris. This is taken at some greater length. When the Court of Appeal heard the submissions in O'Brien's case, you'll see there was a parallel argument developed in a case called Walker and Innerspec. You'll have seen that in the judgment. The issues were very similar. I've set out what the year 2000 point does, and I don't repeat that, but in 14, Walker's case, the facts were set out by the Court of Appeal in this way, in the box. He'd worked for Innerspec from January 1980, long before Directive 2000, until his retirement on the 31st of March 2003. A member of Innerspec's pension scheme. Rule 8.1 said if a member dies on or after the 1st of December 1999, leaving a surviving spouse, that spouse will receive a pension for life. At the date of retirement, Walker had been living with a male partner for a long time. Directive 2078 established a general framework. The UK was required to transpose by the 2nd of December 2003 The Civil Partnership Act came into force on the 5th of December 2005. Mr. Walker and his partner registered a civil partnership on the 23rd of January 2006 and have since married. The question on this appeal is whether Mr. Walker is entitled to require the pension fund to pay a surviving spouse pension to his husband in the event that his husband outlives him. And the Court of Appeal said no for exactly the same reasons they said no in relation to Mr. O'Brien. There was, in his case, a domestic statutory rule in the Equality Act which prohibited this, and so there was an argument as to whether that had to be set aside or read down in some way or another. Mr. Coppell acted as an intervener for the government legal department on the Walker case and made submissions exactly the same as Mr. Kavanagh's. They marched hand in hand, as we see, the Court of Appeal's judgment. And you can see that they made reference to the turnover line of authority and how Lord Justice Lewison at 14 dealt with it. It is, to my mind, clear that pension rights attributable to a particular period of service are acquired definitively during that period of service. The legal situation created by that period of service is definitively fixed on expiry of that period of service. Now, of course, that's completely inconsistent with Lesar, but he didn't have that in front of him. But that's why Mr. Walker lost. And the submissions made for Mr. Coppell are then set out in the next box. You can see that he rejected the submission made for Mr. Walker by Mr. Martin Chamberlain, who acted for him. You'll see at the foot of page 8 that the future effects principle did not avail Mr. Walker. His pension entitlement was definitively established, permanently fixed, as he earned it. So taking the turnover Collarole line. But in parallel with that, there was a reference to the court in a case called Paris, raising almost identical facts. The key facts are set out in paragraph 21. I'm going to ask, if I may, to skip over them and ask this court to accept from me that the facts are almost exactly the same. Well, I'm told that's disputed, in which case I shall have to take a minute to do it. The AG summarised them as follows at paragraph 17 and following in her opinion, just published a few days ago, 7 days ago. He was born on the 21st of April 46, he's dual Irish-British nationality, lived with his same-sex partner in a committed relationship for 30 years. National Court is satisfied that Paris and his partner would have married or contracted a civil partnership many years ago had it been legally possible. And then civil partnership couldn't be recognised in Ireland at the time. When he was 63, Dr. Paris's civil partnership was not recognised until the 12th of January 2011, and then only prospectively in accordance with a ministerial order. 4 years after the recognition, Dr. Paris went on to marry his partner. Paris was employed as a lecturer in Trinity College from 1972 to 2010, admitted to a non-contributory member to the pension scheme, has drawn on his pension under that scheme since his early retirement on the 31st of December 2010. Just over a year before then, 3rd of December, the pension fund, being in serious financial difficulties, transferred to a state agency. In accordance with Rule 5 of the terms of the pension scheme, a member spouse or civil partner is to receive a pension for life equal to 2/3 that where the member dies before that spouse or civil partner. That right, that's the successor right, exists only if the marriage or civil partnership was entered into before the member reached the age of 60 or before he retired, whichever is the earlier. And he then made the application for a survivor's pension. I think it must mean for a declaration of a survivor's pension. And that application was rejected under Rule 5. It will be seen, therefore, that Paris, like Walker, worked before and after the directive. Paris married after he retired. Civil partnership before he retired was not recognised. He, like Mr. Walker, wished to establish a right. The only real difference between the two cases was in the formulation of the bar in taking earlier matters into account. In Walker, there was a rule against taking periods of employment into account earlier than the date of the Civil Partnership Act, whereas in Paris's case, the relevant rule applied was that the marriage didn't take place after the age of 60. but that event took place after the date for transposition. Mr. Koppel was briefed to make submissions to the European Court, and he did so entirely in line with the submissions he'd made to the Court of Appeal. And you can see the submissions that were made later on. I'll come to that in a second. O'Brien's application, PTA, made reference to Walker and so on. The Walker case is in the list for a PTA consideration in due course. A few days ago, we saw the submissions that had been made to the CJEU, and I can pick them up at paragraph 33. I'll pick them up at 33 onwards. First, however, in order to resolve this difference, that is to say, the difference as to what Paris is saying, the AG's opinion, this court will need to see the submissions that Mr. Koppel had advanced, because there is not the slightest doubt that they were specifically rejected by the Advocate General in her opinion. Her opinion's at bundle 3 at tab 31, and 993 to 1026 are the passages that I've put in the box. But you can take this from my note because I've simply copied and pasted it in there, and it'll be probably quicker for me to do it that way.
You said 26A that Mr. Koppel said he would support PTA in the Walker case. Is that right?
I'm sorry, 26A, yes. Mr. Koppel, sorry, the paragraph again, my lord.
26A?
Yes. In Mr. O'Brien's application, PTA made reference to the Walker litigation and said he would...
Oh, sorry, Mr. Brown would support.
Yes. No, we've said we would support PTA in Walker.
Sorry, I thought you were talking about Mr. Koppel.
No.
Never mind.
No.
That's surprising.
Would have been surprising, yes.
Yes, I was...
That would be surprising. Paragraph 34 of my note, referencing 39 in the opinion. The UK raises the objection that Paris's pension entitlements were based almost entirely on periods of service completed prior to the entry into force of the directive, and cannot therefore be subject to the principle of equal treatment under that directive. That was the AG's understanding of the submission. However, that objection is unfounded, for it is settled case law that a new rule of law applies from the entry into force of the Act introducing it, and while it doesn't apply to legal situations that have arisen and become definitive under the old law, it does apply to their future effects and to new legal situations. It's otherwise subject to the principle of non-retroactivity of legal acts only if the new rule is accompanied by special provisions which specifically lay down its conditions of temporal application. And I can tell you there's no controlling limitation in the Part-Time Workers Directive, or indeed Directive 2000. Indeed, it's well established that only the Court of Justice can apply a temporal limitation, not a domestic court. That will be, I'm sure, common ground, but it's set out in Maruco for what it's worth. Unsurprisingly, Mr. Koppel advanced to the CJU essentially exactly the same submission as he'd made in June and July. The core relevant submission by me and Mr. Koppel is set out, paragraph 13 in the core bundle. I read it in the box. The fact that the complainant accrued the entirety of his pension before the introduction of civil partnerships into Irish law, and therefore before it would have been possible for him to make any complaint of discrimination, contrary to the directive, in the availability of survivors' benefits, creates a further obstacle under his directive, which is that the directive does not have retrospective effect. The UK submits the directive cannot require the payment of a pension, whether a survivor's pension or any other type of pension, the right to which was accrued at a time when the prohibition of discrimination of the directive was not in force or had no effect. He cited Tanova and he cited Barber, and his submissions mirrored those of Mr. Kavanagh to the Court of Appeal in O'Brien and Walker. And he concluded, there's a long passage here which time does not permit me to read, but you can see at the end of it, he says, and I picked it up in 38, the correct focus is on the law during the period in which the rights were earned, not at the point at which the pension may come to be paid. And that was his submission. It's exactly the same as the MOJ submission, and it was rejected by A.G. Cocotte. I've already shown you that. For convenience, the whole of her judgment, her opinion, is set out in the box in paragraph 41. And in the remaining parts of this note, which time does not permit me to go through, we have shown how her reasoning in paragraph 42 and 43 is based on existing case law, two cases called Moroni and, I've got that wrong, Maruco and Roma. And
43 is...
so sorry, my lord, I didn't hear you.
43 looks as though it's a critical paragraph.
It is indeed. It is indeed, yeah. Although, in fact, I mean, there's much in 42, too. If I may, we've dealt on 43 in our written submission, but if I can just pick up in 42, the court has already declared Directive 2000 to be applicable to cases concerning occupational survivors' pension schemes, the entitlements under which had arisen, much as they did here, long before the entry into force of that directive, and any contributions or reference period in respect of which also predated the entry into force of that directive. The footnote to that is 20, which is Maruco, which we've got in the bundle. Unlike in Barber, for example, concerning Article 119, the court expressly did not apply a temporal restriction to the effects of its case law relating to occupational pension schemes under Directive 2000/78. So the Advocate General Cocotte is saying, bluntly, Barber's not relevant. It's all about temporal limitations and how to construe those. And that is our submission, why Paris, the Advocate General's opinion in Paris, helps us, and why we...
Well, she goes on to explain why, in fact.
Absolutely does.
Sentence, that there was no longer effectively a legitimate expectation after the decision in Barmer.
All the points I've already made to my lord. All the points I've already made to my lord in paragraph 42, and which we'd attempted to make to the Court of Appeal, and which provides a complete explanation as to why you don't see any reference to the Barber set of jurisprudence and the turnover jurisprudence in Bruno and Patini, or indeed in the earlier reference in our case. It's just it's a different chapter of the book, if I can put it like that. Time's run out on me, but if I can just bring you to our concluding page, paragraph 19. Page 19. Lessard and Felber before it are completely inconsistent with the MOJ submissions. And we say for that reason alone, this case is not act clear against Mr. O'Brien, and for that matter, Mr. Miller and the cohort of judges in that case. Secondly, Advocate General Cocotte's opinion has directly addressed the arguments of the MOJ and the GLD, does not support the MOJ, and does cast significant doubt on the judgments of both the AT and Court of Appeal. Again, on that basis, it cannot be said it's act clear against Mr. O'Brien, and we therefore say it would be wrong to dismiss the PTA applications. Now, we recognise, of course, the CJU could reject the AG's opinion, but it submitted that it's more usual by far that it should agree. We've pointed out, we've spoken to the registry, the judgment in Paris won't take place until sometime in the autumn. The possible courses, therefore, were set out in 57, and bearing in, you can read those, I won't spend time on them, but we do point out 58. Mr. O'Brien is 76, many of the other judges are in their second half of their 70s. This litigation started in 2005. We need to get on with things because of Article 50 and the referendum, and that's why we suggest the course of action that we have. My lady, I've run out of time.
Thank you very much, Mr. Allen.
Thank you.
I'm not entirely sure whether Ms Krasner is entitled to be invited on this application, whether she wishes to add anything, but I'll ask
Got
her
nothing
anyway.
further to add, but thank you.
Yes, Mr.
Do you want
Cabinet.
to have a second? Do you want this?
No, I'm fine, thank you. My lady, my lords, in our submission there are 3 relevant propositions of European law which provide a complete answer to both O'Brien and to Miller. But as far as O'Brien is concerned, all 3 propositions are relevant. So far as Miller is concerned, only the 3rd. But as the Court of Appeal found, and as Sir David Keane found in the EAT, in our submission rightly, all 3 propositions are act clear. So may I start by enumerating those propositions? Proposition 1 is this, that the Part-Time Workers Directive upon which these claims are founded does not have retrospective effect. That's common ground. It's recorded at paragraph 2 of the Court of Appeal's judgment. And it follows from that in order to be a breach of the directive, the breach must take place after the deadline for implementation of the directive into UK law, which was the 7th of April 2000. So proposition 1, EU legislation is not retrospective unless it expressly says so, and nobody argues that this directive says so. Proposition 2 is the future effects principle upon which Mr. Allen's case entirely rests. And this principle means that new EU legislation applies to pre-existing relationships, such as, for example, a contract of employment, from the moment of implementation, but it does not apply to a legal situation which is permanently and definitively fixed before the date for implementation. So the future effects principle dovetails with, it doesn't detract from or contradict the no retroactivity principle. It doesn't undermine the principle that the breach must happen after the date for implementation. And as Mr. Allen said, I rather inelegantly called this the hit the ground running principle, that you don't have to wait years and years and years for the EU legislation to take effect to existing relationships. Proposition 3 is the one that's specific to pensions. Proposition 3 provides that where pensions are concerned, the entitlement in cases like the present is permanently fixed at the point of service to which the pension rights are or would be accrued. It's not later, it's not when the person retires or when the pension comes into payment. I'll come to the cases very briefly in a minute, but that's Tenover, Cullerell, all the cases like that. Tying those together, in Mr. O'Brien's case, the future effects principle doesn't operate so as retrospectively to provide Mr. O'Brien with a right to claim under the directive in respect of pension that's attributable to service prior to the 7th of April 2000. It does mean that the fact that he was already in service before the 7th of April 2000 didn't disqualify him from claiming in relation to service after that date, which was the mistake Latvia made in the O'Brien case in the Court of Justice. But in our respectful submission, those 3 propositions are act clear and determine the O'Brien case. As for the Miller case, the time limit case, only proposition 3 is relevant. Because if we're right that your entitlements accrue as service takes place and that the breach happens as service takes place, then applying regulation 8.2 of the part-time workers regulations, time starts to run from that breach, and therefore the breach came to an end when your part-time service came to an end. My learned friend's argument is predicated on the footing that the breach only happens when you retire. And in our submission, that's simply incompatible with the Court of Justice jurisprudence. And as I've submitted, both the Court of Appeal and Sir David Keane regarded these three propositions as being act clair. My Lord Reid, early on in my learned friend's submissions, asked whether there was a separate domestic law point in relation to the time limit issue over and above the EU law points. In my respectful submission, there isn't, because in order to succeed with their time limit point, they have to show that the wrong happened at the point of retirement, not at the point of service. And in order to do that, they have to persuade you or the Court of Justice that 10 over and all of the cases that are authority for Proposition 3 are wrongly decided. So, in my respectful submission, there is no additional point, and that is why my learned friends, if I can put it this way, threw in the towel on Miller when they lost O'Brien in the Court of Appeal. They acknowledged that the two cases stood or fell together, and that is still, in our submission, the position. My lords and my lady, I won't take you through the Court of Appeal's judgment.
You've been extremely clear, Mr. Kavanagh. You may be right, you may be wrong, but you've certainly been extremely clear. I'm wondering what you can add to.
Well, my lady, what I'm going to do, as briefly as I can, and I won't take you through the Court of Appeal, is take you to a couple of the authorities in support of the propositions that I say are act clair, and then take you to Paris and to Lézard, which are the two key authorities that my learned friend says are inconsistent with those principles.
Are you going to, I mean, it may not matter, but are you going to deal with the point that he was making about employment, an employment judge being treated as a separate person
Yes.
from an immigration judge?
Yes, may I do that now? My lords, my learned friend didn't give you a comprehensive list of the types of case for which the time limit issue arises. The paradigm case is a case in which somebody is a fee-paid part-time judge up until a certain date and then takes a full-time appointment, and then many years afterwards retires from his or her full-time appointment. Therefore, the wrong, which we say crystallised during service, comes to an end many years before they retired. They brought their claim within a time limit if time started to run from their point of retirement, but they were many years out of time if time ran from their part-time service.
That's treating the fee-paid appointment as a separate appointment from the full-time appointment.
More than that, my lord, it's treating the wrong as coming to an end when the fee-paid appointment comes to an end, because once one becomes full-time and salaried, you're permitted to enter the pension scheme.
Yes,
so even if it were a single employment, the problem stops at the point of becoming a full-time salaried person. I think it's at page 214 of the core bundle that the Employment Tribunal's judgment sets out the categories of case in which the time limit issue arises. It's paragraph 6 on page 214. So 6.1 is the paradigm case, fee paid becoming salaried, and they don't claim within 3 months of the end of their fee paid service. Then, same scenario, but after one's retired from full-time service, you come back and take another fee-paid appointment. The third is the category that my learned friend referred to, where you have a sequence of fee-paid appointments. And bearing in mind that all of these claims, now I can't say that all of these claims predate 2000, where we're talking about the Miller claim, but it wasn't, as I recall it, suggested that if you were an employment judge and then obtained a separate appointment as an immigration judge, as used to be the position, that those were to be amalgamated and treated as a single appointment.
It's already pre the new system.
Exactly, so it's pre the impact of fees on employment tribunals and the consequences that followed. So the Miller case, this is really why I respectfully submit that the Miller case comes back to the third proposition. Unless it can be said that the harm is done, the breach happens, the wrong takes place at the time of retirement, they're out of time. Now, as regards what my learned friends say, with respect and with admiration for their industry, we submit that there's not a single authority to which they can point which challenges, let alone undermines, the three principles I've just enumerated. There are no cases anywhere in the Court of Justice's jurisprudence that doubt Tenover, Collarole or Barch, which are the three I'm going to focus upon, let alone expressly departs from them. and this is the key point in relation to my learned friend's submissions, the cases on which my learned friend relies, for example, Paris and Bruno and Pettini, are cases that are different from the present in that in the particular circumstances of those cases, the wrong happened after the relevant directive came into force. It's a different type of wrong in those cases. And so they're not cases in which there is an issue as to the retroactive effect of the directive concerned. It's a simple and straightforward cases in which the breach happens afterwards, and the fact that the relationship existed prior to the coming into effect of the directive is neither here nor there as a result of the future effects principle.
I mean, the argument against you is that the Barber line of cases, including Turnover and Colorol, rather like Dufresne against Sabina before them, are exceptional in that the court imposed a temporal restriction on the effect of the judgments in order to protect legal certainty. And the argument would be, obviously, that consideration is absent from the present cases.
Yes, my lord, several of the cases, I'm afraid we have an overlarge bundle already. We haven't burdened you with all the authorities on this issue, but Barch is not a Barber case. Vröger, which is in the bundle, is not a Barber case. So the principle that pension entitlements accrue during service is not an aspect of the Barber principle. Barber set the context in which the issue became relevant, because once Barber had said that the shutters came down on, I think it was a date in May 1990, it was necessary then for the court to explore what that meant in practice, whether it meant it related to service up to that date, as it later found, or whether it meant retirement after that date, and so forth. So my lord, it's true that Turnover arose in the context of Barber, but its reasoning, the part of the reasoning upon which we rely, isn't inextricably linked with the Barber principle. My lord, it's no longer, as I understand it, really an issue in argument between the parties as to whether the Court of Appeal got the Silfit approach right.
Well, we're going to make up our own mind.
You can make up your own minds. My only point is this, that it's no kindness to the judges to drag this matter out if the position is act clear against them. And so what I'm now going to do, as I've already indicated, if I may, is take you briefly to the key authorities in favour of these three propositions, and then address the two authorities, the main authorities my learned friend relies upon. As for no retroactivity, the principle is very helpfully set out by the Advocate General in the Paris case, which is in Volume 3, tab 31, at paragraph 40. Indeed, it helpfully sets out simultaneously the no retroactivity and future effects principle.
In Paris case.
In Paris's case, in the Advocate General's opinion, paragraph 40, which is on the fourth page of the photocopy. You may have it loose because we enclosed it.
Well, we've got it in two. Yes, but the page 1000 is in a separate document, of course. It's not in the same.
I'm so sorry. I didn't appreciate that.
But we have it in two places.
I'm so sorry.
Probably three.
I fear so. If the court has at least one of those in front of it. It's paragraph 40. And I'll come back, of course, to paragraphs 40 to 43 in a moment. But in this paragraph, she says that it's settled case law that a new rule of law applies from the entry into force of the Act introducing it, and whilst it does not apply to legal situations that have arisen and become definitive under the old law, it does apply to their future effects and to new legal situations. It is otherwise subject to the principle of the non-retroactivity of legal acts, only if the new rule is accompanied by special provisions which specifically lay down its conditions of temporal application. And she's helpfully at footnote 19 collected the court's case law on this issue. Just for your note, a similar exercise was conducted by the Court of Appeal, paragraphs 5 and 6 of the Court of Appeal's judgment, where they set out the leading authorities of the Court of Justice, both on the no retroactivity principle and on the principle of the future effects principle. And the cases that are referred to in footnote 19 of Advocate General's Cocott's opinion include Broccoli, Carter, a case I can't pronounce, Prokovich, Meyer, and a number of others. So the distinction between those cases that are caught by the no retroactivity principle on the one hand and those cases that are caught by the future effects principle on the other is when the right in question is permanently fixed. And there is one helpful authority that spells that out very explicitly, which is tab 14 in volume 2 of your bundles, Centeno Media Via. And it's at paragraphs 61 and 62 of the court's judgment, which is on page 440 of the bundle. This was a case about applicants for jobs in the European civil service who argued that they were guaranteed the grades that the jobs were advertised at, because when they were ultimately appointed, they were appointed to a lower grade. And the question was when the right to a particular grade became fixed. But in the course of considering that, at paragraphs 61 and 62, the court says that it's well established that amending legislation applies unless otherwise provided to the future consequences of situations which arose under the previous legislation. That is so except for situations originating and becoming definitive under the previous legislation which create acquired rights. And there's a citation of the usual suspects of authorities that deal with that issue. So, in my respectful submission, those are the cases that are authority for the first two propositions. The most important proposition for present purposes is the third, that where rights to a particular amount of pension is concerned, the entitlement is permanently fixed at the point of service at which the pension rights are or would be accrued, not when you retire or when the pension comes into payment. And so in considering that issue, the question is when your right to pension for a particular period of service becomes definitive. The leading authority is 10 over, and 10 over you will find in volume 1.
Well, I mean, while at least I still have Paris in front of me, isn't it implicit in the Advocate General's approach? If you look at what you've taken us to paragraph 40, and then we see what she says at paragraph 43, rightly or wrongly, she seems to be taking the view that the quantification, the calculation of future pension scheme payments is a matter which has not become definitive under the old law.
Yes, my Lord, that's because there was a different breach in issue in Paris. May I just very briefly submit what it is, and then I'll come back to it in greater detail. The thing about Paris is that that dealt with rights that were dependent upon marital status and discrimination on sexual orientation grounds. Now, in the Maruco case, the Court of Justice had said that the right to bring a claim because you don't get a widower's pension if you're gay and you would if you were heterosexual is not one that automatically kicked in when the Framework Directive came into force in December 2003. It only came into force when your particular state recognised gay marriage or a form of civil partnership that was akin to gay marriage. In Paris, the Irish government and the UK government had argued that civil partnership was recognised for the first time in Ireland in 2011, which was after Dr. Paris had retired, and therefore he was caught by the no retroactivity provision, that there was no breach at the time when the law applied to him. The Advocate General rejected that because she took the view that the breach actually became unlawful, that this type of activity was a form of indirect discrimination that became unlawful from 2003 onwards. And since Dr. Paris had remained in the pension scheme until 2010, there was actually no problem with the retroactivity provision. There was a breach that carried on throughout the period in which the relevant legislation was applicable.
Yes, but if I can interrupt you, she doesn't confine the the impact of the directive on the calculation of the pension to the period after the directive came into force. I mean, the point she makes in paragraph 42 is that the entitlements had arisen in the case she's referring to, much as they did here, long before the entry into force of that directive. And then she tells us in 43 that well, at least I take it from what she's saying in 43, that the periods prior to 2003, when the directive came into force, are to be taken into account in the calculation of the pension payments.
Yes, but she's dealing with a different issue, you see, with respect. She's dealing with this issue as to whether there is a temporal limitation, which itself depends on whether you accept that the right started to exist in 2003 or the right started to exist in 2011. If one looks at paragraph 43, first sentence, she states a proposition which entirely supports our case. The court has held that the prohibition on discrimination contained in the relevant directive can't give rise to claims for payments in respect of periods in the past that predate the time limit for transposing that directive. And she refers there, paragraph 23, to a section of the Roma judgment, which includes paragraph 64, which in turn refers back to 10 over. So what is the difficulty, in my respectful submission, with my learned friends relying upon this passage is they are trying to shoehorn some general statements on a different subject as if they are relevant to the issue that we are currently dealing with.
Well, at the moment, I'm reading the second sentence of paragraph 43 as meaning that a future pension, the future pension scheme payments are not payments in respect of periods in the past.
Yes, but one has to, in my respectful submission, one has to read that against the background that this is a case in which the period of service is of no relevance, because the type of breach concerned a qualification that had to be satisfied before you retired, i.e. get married before the age of 60. And so this wasn't a case like 10 over and Barch is perhaps the dichotomy of this case, which show that where there is an entitlement that is based upon service and it all happens prior to the date of the breach, then you are unable to rely upon the future effects principle. There is another passage in this judgment which my learned friend hasn't taken the court, which we say perhaps makes the point more clearly than I've made it at the moment, which is on page 14.
Which paragraph?
105, 106 and 107. The situation here is no different from that in Maruca and Roma, whereas here certain benefits were claimed only in respect of the period after the state had recognised same-sex civil partnerships, even though the origins of those benefits, contributions or relevant periods of service, lay in the distant past, that is to say, before the institution of civil partnership was created. There is nothing in the directive to indicate that its provisions confer protection exclusively in relation to legal relationships that were established after its entry into force or after the expiry of the time limit for transposition. If the legal effects of a fundamental principle, such as the EU law principle of equal treatment, were exclusively restricted to entirely new relationships, take years or decades for all citizens to benefit from its protection. As I've already said, it's therefore a matter of general principle that a new legal provision, such as the prohibition on discrimination, is applicable not only to entirely new legal relationships, but also to the current and future effects of legal relationships that came into being under the old law. This may very well mean that discriminatory provisions enacted in the past must henceforth be interpreted and applied in accordance with EU law, or may have to be disapplied altogether. So the point is that to obtain the full survivor's pension in the Paris case, all that was necessary was that you had to marry before the deadline, and the deadline came after the law came into force. You didn't have to be married at the time of all of the service. In Mr. O'Brien's case, in order to get a pension in respect of service in 1998, you needed to be a full-time judge in 1998. And that's, in a nutshell in our submission, the point of distinction between our case on the one hand and this case and Bruno and Pettini on the other. And so passages looked at from Paris, and indeed, well, there aren't any unhelpful passages in Bruno and Pettini, but in passages in Paris, in my submission, don't and cannot be regarded as overriding the very well-settled principles of law that have been set out for over 20 years by the Court of Justice in the jurisprudence following on from Tenova and following. And if that were to be intended, then the Advocate General surely would have said so. She does cite Tenova in a different context in one of her footnotes, and Tenova was referred to in the submissions by the UK government. So if she was going to do something as cataclysmic, as significant as to overturn this case law, then surely she wouldn't have done it sub silentio.
You mentioned the Barch case as being a significant one. I don't ask you to look at it. Is that the one at volume 212?
Yes.
2009.
Yes, I will, in fact, if I may take you to it in a moment, because...
You got deflected onto Paris, didn't you?
I came to Paris, but I was going to make these submissions. It's helpful anyway, because I would have been making these submissions. But perhaps in order to lay the groundwork for what I was to say about Paris, can I start with Tenova, which is in Volume 1. The Advocate General's opinion is at tab 5, and the judgment of the court itself is at tab 6. Now, the issue of whether pension rights accrued at the time of service or at the time of retirement arose in Tenova because of the application of the Barber limitation, but it wasn't specific to the Barber limitation. And the key passages are in the opinion of Advocate General Van Gerven at page 105. Well, perhaps I won't read it to you because that just identifies that the issue arises in the Barber context. But at page 110, on the lower left-hand page, in paragraph 17 against the lower hole punch, he says this: in practice, an employee accrues pension entitlements on the basis of his periods of service with the employer concerned. For that purpose, contributions are periodically paid to a particular pension fund by the employee and or employer in respect to specific periods of service.
I'm sorry, which paragraph are you reading from?
I'm reading paragraph 17, left-hand column.
17.
On page 110.
Well, you've given us a different...
I do apologise.
In the bundle, the case starts at page 143.
Yes, my lady, I was just... it's the... My lady friends has put the Advocate General's opinion in two places. I'll take it from the version that you've got. It's also in tab 5. So I'm Fred.
You told us tab 6, so I went to tab 6.
I'm sorry, did I? I'm sure it's entirely my fault.
Don't worry, I just need to know where you're reading from.
It's paragraph 17 of the Advocate General. Perhaps if I specify the paragraph numbers. 170.
Yes,
Thank
it
you.
is. It is.
And at paragraph 18, he says that it seems to me that in Barber, the court recognises, if only implicitly, the distinction between the accrual and the falling due of the occupational pension. The court's conclusion that pension payments constituted pay can be so understood. This is because, from the point of view of Article 119, benefits paid under an occupational pension scheme are to be regarded as a form of deferred pay, which the worker has accrued in respect of his service with one or more employers during a specific period of employment. And then 3 lines down, it is the service itself, and in some cases the relevant contributions, which give rise to the employee's pension rights on the one hand, and the obligations of the employer and or the trustees of the pension fund on the other. Any sex discrimination occurring in this field after that date, taking into account different pensionable ages, thus falls under the prohibition laid down by Article 119. And then moving to the second paragraph within paragraph 19, which is against letter E, The distinction between accrual and the falling due of the pension helps to clarify matters, since it's the service itself, and in some cases the relevant contributions, which give rise to the rights and obligations of the employee and the employer, and or of the trustees of the pension scheme. It may reasonably be assumed that using the expression legal situations which have exhausted all their effects in the past, the court had in view situations in which the right to a pension had already been acquired by virtue of periods of service prior to the judgment in Barber. The coming into being of a pension right on the basis of a period of service in the past leads indeed to a legal situation whose effects are exhausted in the sense that the worker has definitively acquired the pension rights relating to that period of service. The melodramatic emphasis I added to the words in that last sentence were, of course, because that echoes the terminology that the court uses when referring to the future effects principle, that you can't rely upon the future effects principle insofar as rights are definitively acquired prior to the coming into effect of the legislation. Then paragraph 20, he explains that the reason for the Barber limitation was legal certainty, which of course also underpins the principles of no retroactivity and the future effects principle. Then one should look at paragraphs 21 and 22, and I'll have to rely on my learned friend for the page number.
21 is the next page, 174.
Paragraph 21. Barber must be interpreted as meaning that entitlement to a pension is entitlement which was acquired in relation to periods of service prior to the date of the Barber judgment. So the focus is upon periods of service. And then at 22, in passing, I would point out that in my view, the third interpretation, which is suggested that the falling due of the pension should be the decisive criterion, irrespective of the time when the periods of service to which the pension relates were completed, can't be entertained under any circumstances. I consider this option undesirable, not only in view of the way described above, in which the pension rights accrue, but also on account of the clear unfairness which this interpretation would lead for a large number of workers. Not a single worker whose pension became payable before that particular date would be able to rely upon the principle of equal pay. So those are the key propositions in the Advocate General's opinion. As for the court, it's paragraphs 17 to 19 of the court's judgment, which is internal page 136 and within the bundle.
205.
Thank you very much, page 205. So having found on the preceding page that a survivor's pension also counted as pay, at paragraph 17 it said that the court's ruling in Barber took account of the fact that it's a characteristic of that form of pay that there is a time lag between the accrual of entitlement to the pension, which occurs gradually throughout the employee's working life, and its actual payment, which is deferred until a particular age. And then 19.
Oh, 18.
18. The court also took into consideration the way in which occupational pension funds are financed, and thus of the accounting links existing in each individual case between the periodic contributions and the future amounts to be paid. Now, pausing that...
That's a factor that's absent from the present case.
It's not, with great respect, my Lord, because contributions were made by the Ministry of Justice or its predecessor to the Consolidated Fund whilst people were in service as judges, as full-time judges. And of course, they were not being made in relation to fee-paid judges. But in any event, as we will see in a moment, the courts have made clear that no different rules apply dependent upon the basis of funding for a pension scheme. Then at paragraph 19, given the reasons explained in Barber, it must be made clear that equality of treatment in the matter of occupational pensions must be claimed only in relation to benefits payable in respect of periods of employment subsequent to the 17th of May 1990, the date of the judgment in Barber. So the ratio of the court was that the right accrued during the periods of service, not at the point upon which a person retires.
Well, I wonder if that is the ratio, because you see it's subject to the exception in favour of workers who had initiated legal proceedings. So they can bring claims of a kind which Barber generally bars, which suggests that the problem that Barber is concerned with isn't to do with the nature of the right or something of that kind. It's simply an issue of legal certainty, which is making them confine the effects of the judgment generally to prospective effects, but with an exception in respect of people who have already made a claim.
My Lord, with respect, no, the two separate points need to be considered separately. One is the nature of the Barber limitation. The Court of Justice has recognised that it can exceptionally limit the retroactive effect of one of its rulings. That's what happened in Barber, but the court made an exception for claims that had already been brought. Mm-hmm. That's why the last few words of paragraph 19 exist. The reason I'm relying upon Tenova is not, of course, because I'm suggesting a Barber limitation applies in the present case. It's because of the light that the consideration in the Tenova case sheds upon when the right to a pension becomes permanently fixed. And in my submission, both those passages in the Advocate General's opinion that I've drawn to your attention and this passage in the court's judgment shows that the predicate, the point upon which the ruling is predicated, is that the rights accrue whilst you are in service. And that's what we respectfully submit Tenova is authority for. Colour roll, I should mention, simply because it makes clear that this applies even if you can't quantify the pension rights until long afterwards. Colour roll is in tab 9, and it was decided on the same day as Tenova. At page, I hope it's 254, yes, page 254, in the facts and procedure, at letter G, one can see that it was recorded that the essential characteristic of such schemes is that their eventual liabilities cannot be known because the pension to be provided on each member's retirement, being related to his earnings near to that date, cannot be known until he or she actually retires. Consequently, the pension can't be funded simply by contributions at a fixed rate, even at a fixed rate set as an artificially high level. The method generally adopted is for the employing members of the scheme to pay contributions and the employer undertaking to pay whatever contributions are necessary to meet the balance of the cost as estimated by the actuary. So it was recognised in colour roll that at the time of service you couldn't be sure what the pension entitlements of the particular individuals ultimately would be. Nonetheless, the court came to the same conclusion as it did in colour roll. That's page 228. Thank you. Page 300. And it, as the court so often does, in fact, it used identical language, the language that it used in Tenova at paragraphs 46, 48 and 49. So the fact that you can't be specific about how much you'll eventually get doesn't detract from the proposition that the right accrues whilst you are in course of your service. Now that, of course, as with Tenova, was the case working out the Barber protocol. I now want to take an example which had nothing to do with Barber, which is the case of Barch. And Barch is in, I hope, tab 13 in volume 2. Yes. And this is a judgment of the Grand Chamber of the court.
Weren't the others Grand Chamber?
Yes.
Yes,
I
indeed
thought
they were.
Tenova was Grand Chamber.
Yes.
They were. I don't think Paris is Grand Chamber, but of course there's no judgment yet anyway. Can I summarise the facts? They're set out in the headnote. This also was a pensions case. It concerned a claim to a survivor's pension by the widow of an employee of the company Siemens, And the husband had worked for Siemens from 1988 until he died in 2004. The wife was denied a pension because she was more than 15 years younger than her husband. And she claimed that this was unlawful age discrimination, contrary to the Framework Directive 2078. But the problem, and that came into force on the 2nd of December 2006, where age discrimination claims were concerned. Just for your note, that's stated at the AG's opinion, paragraph 12. Her problem was that her husband had died before the time limit for implementing the provisions of the directive had come into force. And so if my learned friends were right, she should still have been able to claim because she was still alive, still able to receive a pension, even though her husband was no longer in service. But the Advocate General repeats the proposition that rights accrue on service on page 415. At least the Advocate General finds that she's unable to claim because all the service had expired before the right came into force. And at the bottom of 415, the Advocate General says the contract of employment created an employment relationship between Mr. Barsh and the company. The survivor's pension is pay, and therefore pay for the purposes of the Equalities Directive. After the expiry of the period for transposing the directive, the validity of the age gap clause would therefore fall to be assessed under that directive. Then over the page at paragraph 106, the AG says, I therefore proceed on the basis that an age gap clause such as that at issue in the proceedings before the National Court is capable of constituting direct discrimination for the purposes of the directive in respect of both Mr. Barsh and the survivor. It must, however, be remembered that at the material time, the period for transposing the directive into national law had not yet expired. And in the judgment of the court, at page 423, the court was considering the question whether there was a more general principle of EU law that prohibited discrimination, which meant that it was against the law to discriminate in this way, even before the age discrimination provisions.
Well, that's the Mangold point.
Yes, indeed. Came into force. And indeed, Mangold is issued. And so in question 14, 4 lines down, it says the court wishes to ascertain whether, or the referring court wishes to ascertain whether, in circumstances such as those at issue in the main proceedings, such a link to community law arises from the directive, even before the time limit allowed to the member state concerned for transposition has expired. And at 16, the court says neither the directive nor Article 13 enable a situation such as that in issue in the main proceedings to be brought within the scope of community law. And then the court goes on to deal with, a little later on, with Article 13, but at paragraph 17, the court says, the guidelines do not constitute a measure implementing the directive, and the death of Mr. Barsh occurred before the time limit allowed to the member state concerned for transposing the directive had expired. So the reason that Mrs. Barsh lost was that the future effects principle didn't enable her to recover, even though she would have been in payment of the pension after 2006. In other words, the case only makes sense if the service is what gives rise to the rights to a pension. And at paragraph 25, page 424, is part of the reasoning of the court that no claim arose on the basis of Directive 2078. Now, I don't have time, I'm afraid, to take the court to the Vroege case, which is another case, not a Barber case.
Which one was that?
Vroege, V-R-O-E-G-E. It was a sex discrimination case, but it was about access to pensions, and therefore it was held that the right weren't covered by the Barber retroactivity provision. But may I come to deal with the cases upon which my learned friends rely? None of them expressly state that they're departing from Tenova or Barch or any of the other cases. And they're all different from the O'Brien case because they're cases in which there was a particular qualifying condition of a type that meant that the breach took place after the date for implementation of the directive. And therefore, to put it more accurately, the legal situation in question in those cases wasn't permanently fixed before the date from implementation. Therefore, they don't engage the retroactivity principle, and it's a simple application of the future effects principle that simply because there was a pre-existing relationship, it didn't mean that there was no opportunity to make use of the new legislation. So both Bruno and Pettini and Paris are cases in which there were unlawfully discriminatory qualifying conditions for the relevant pension benefits, which conditions continue to apply and continue to bite after the date for implementation. So the contrast is this, that in Mr. O'Brien's case, if he wishes to claim a pension for 1997 or 1998 or 1987, he needs to show that he was a full-time judge, or that's what the rule provided, that he had to have been a full-time judge in those days. In other words, there was a qualifying condition that had to be met at that time in order to claim a pension for that time. In contrast, in both Bruno and Pettini and in Paris, the nature of the discriminatory qualification was entirely different because in Bruno and Pettini, you had to comply with a requirement by the end of your service. It was that over the life of your service, you'd done 1,821 weeks of work. And in Paris, the requirement was that you had to have been married by the age of 60. Now, the claimants in Bruno and Pettini and Dr. Paris all continued in service after the deadline for implementation of the relevant directive expired, and that meant that there was discrimination still taking place in both of their cases after the date for implementation. And this meant in turn that the court didn't need to give retrospective effect to the rules against discrimination in those cases, because the discrimination that was the subject of the litigation was in time. It was taking place after the directive came into force. In Mr. O'Brien's case, it's different, because the rule in Mr. O'Brien's case was not that you had to be a full-time judge before a particular date, sometime after April 2000. It was that you had to be a full-time judge in 1987, 1997, and those years, each particular period of service. So, in my respectful submission, that's the key to understanding the difference between the two cases and why they're ships passing in the night. The Paris and Bruno and Pettini cases are not cases in which there is any inroad into the principle that was adopted in Tenova. Now, it would have been different in Paris if he had retired before 2003, because if Dr. Paris had retired before 2003, all of his service would have been prior to the date in which the treatment became unlawful, and his claim would have failed. As I said, what the UK government and what the Irish government were arguing in the Paris case was that the deadline for the law becoming alive was not 2003, but 2011, because that's the point at which treatment on marital status grounds between gay and heterosexual people became unlawful. But Advocate General Cockott didn't accept that premise. She took the view that the discrimination took place from the date of 2003 because it was a form of indirect discrimination that affected everybody, whether they were married or not. You didn't have to be a married gay person to suffer the discrimination of the sort that was identified in Paris. So, as I say, the UK government takes a different line. The DWP didn't agree with what the Advocate General decided, but that is what the Advocate General decided. And it's important to note that my learned friends, with respect, make a mistake when they say that the facts in the Walker and Innerspec case are on all fours with the facts in Paris. And that's because they've misunderstood the facts in Walker in one key respect. May I ask you to take up my learned friend's note that was filed yesterday afternoon? On page 7, paragraph 15, they say that the Walker case was the same as the Paris case because Mr. Walker worked before and after the Equalities Directive had to be transposed, which you'll recall was December 2003. In fact, that's not right, because as you'll see from the box immediately above it, Mr. Walker worked for Innerspec until his retirement on the 31st of March 2003. All of his service took place prior to the 2003 directive coming into force. In any event, the Court of Appeal found that the deadline for him was 2005, because that was the point at which the UK recognised civil partnerships. But the key point of distinction between Walker and the Advocate General's opinion in Paris is that in Walker, all of the breach took place prior to the EU law taking effect, whereas in Paris, the breach continued after the EU law came into effect. The fact that Paris is all about the qualifying condition is made clear by the Advocate General at paragraph 28 of her opinion. I'm afraid I've got lost as to where the court will find.
Well, in
Tab 31.
several different
Grateful.
places. Yeah. But what's the paragraph number?
Paragraph 28. Last sentence. The only point of contention in the present case is a provision in the terms of the scheme at issue to the effect that the employee concerned must have entered into a marriage or civil partnership before he reached the age of 60. So that's the only issue that arose in Paris, and that, on the Advocate General's understanding of it, was a breach that carried on beyond the date in which the law came into effect in December 2003. Indeed, if one goes back to the preceding page, paragraph 22, you'll see that once you're through the gateway of being married before you're 60, there's no problem with quantification of your pension.
And when was Dr. Paris 60?
Dr. Paris was 60 in 2006. That's at paragraph 18. So he's 60 in 2006, he retires in 2010. UK and Ireland says he's out of luck because the treatment only became unlawful when civil partnerships were recognised in Ireland in 2011. Advocate General Cockott says that's a misunderstanding because this is a form of indirect discrimination on sexual orientation grounds, which was rendered unlawful from December 2003. But the point about paragraph 22 is that once you're in the scheme, then you're entitled to the same survivor's pension as anybody else, 2/3 of your partner's pension. At paragraph 33, she accepts that pensions are deferred pay. And that's a reference in the footnote there to 10 over, so she was aware of 10 over. And in the section dealing with temporal scope, I've run out of time to do this. May I just give you for your note the passage in the judgment that shows that Advocate General Cockott rejected the argument that the law only came into force in 2011. It's paragraphs 54 to 60. The passages upon which my learned friend relies, 40 to 43, in our respectful submission, must be read against that background, because this was a case in which, in Advocate General Cocott's understanding, simply didn't give rise to the complications of a need to rely upon the future effects principle. It's a much more simple case, the question whether the very fact that he was already in the pension scheme prior to 2003 disqualified him, and the answer, of course, is no. And again, I'm very conscious of the time. Paragraphs 40, 41, 42, and 43, in my respectful submission, when one unpicks them, are simply setting out the orthodox principle that you are not disqualified from bringing a claim in relation to pensions just because your service started before the period in which the law became effective. No, I haven't finished. You were 5 minutes late. And as I've already submitted, you can also find at paragraphs 105 to 108 passages that emphasise that this is all that Advocate General Cocott was doing. Would in our submission be extraordinary if she was seeking to depart from such well-established jurisprudence? In the last few minutes, may I just deal with the Lazare case that my learned friend also refers to. This is of no assistance to them, we say, for 7 points. Each is very short. The first is that this is a case in which the no retroactivity FEP 10 over principles were not raised by the parties. It was conceded by the employer that the directive applied. See Lazare judgment, paragraph 18. 2, no doubt as a result, the questions put to the court don't raise the future effects principle or 10 over. See Lazare, paragraph 16, and the court doesn't deal with matters that aren't raised in the questions before it. 3, none of the principles my learned friends seek to derive from the case are even mentioned in the judgment. Again, if the court was going to do something as drastic as to depart from 10 over and Barch, one would have expected it to say so. 4, the explanation why they didn't deal with it is that the point didn't arise since both claims failed. So there was no need to examine the temporal scope of the rights in issue. Fifth, my learned friends therefore are simply inviting you to work backwards from the outcome, not to rely upon anything actually said in the judgment, but there are 2 possible explanations for why the court didn't deal with the no retroactivity provision. The first is that it's not entirely clear from the judgments, but it may well be that the Austrian law was still in place. That meant that but working for somebody else or being a student prior to the age of 18 is not to be taken into account. So it was still necessary for the court to think about it, and Barch is an example of the case where the court analysed the law, even though they ultimately said there was no claim because of the retroactivity provision. And finally, there may be a further reason why the 10 over principle wasn't considered, which relates to the nature of the subject matter of the claim. It wasn't about pension entitlements in the normal sense. It was about pension credits for time in full-time education, in the Felber example, and in apprenticeship in the Lazare case with somebody else. So this wasn't a case of deferred pay in the classic sense in any event. And indeed, it's treated by the court as coming within a social security exception to the relevant directive, Article 6.2. So the questions or the reasons line up in our respectful submission why this doesn't enable my learned friends to rely upon these authorities. My lady, my lords, I won't give you a peroration unless there's anything else. Those are my submissions.
Well, thank you very much indeed, Mr. Cabinet. Mr. Bourne, do you wish to follow?
No, thank you, my lady.
My lady, my lords, I think I speak on behalf of all counsel for saying that we're grateful to you for allowing us to make our breathless submissions to you so quickly. And
No, we
hope-
like them breathless.
You like them breathless?
Yes.
Well, there we go. I shall remember that for future. I've got some short reply points. I have made one mistake, and I've been corrected by Mr. Kavanagh. I got the dates wrong in the Paris case, and I'm grateful to him for correcting it. It does not make the slightest bit of difference to the submissions that we make. The submissions we make, set out in our note, show in terms that there was a rejection of Mr. Coppell's submissions, which were a rerun of the submissions that he had made in the Court of Appeal in the Walker and Innerspec case. We've set out those submissions. They are directly in point, but they are rejected, as you can see. We stand entirely on that passage 40 through to 43 in Paris, as saying they provide a good reason to say this is not Aclair against us. That's Paris. Secondly, we acknowledge fully that there are a series of cases from Turnover onwards. We've said so throughout. We've given you our reasons why we say that stand apart. My friend took you to Collarole, which quite rightly, he says, points out that even in cases where there is a non-contributory pension and the exact extent of the benefit can't be established until the end, paragraphs 44 and 45 of the Barber judgment are to be construed in the way that Advocate General Girvan had suggested in his opinion in all those conjoined cases. There's a very short answer about Collarole. Frankly, if Collarole had been treated as an exception because it was a non-contributory pension, and Article 44 and 45 had been construed in some different way, there would have been endless further litigation about what fell into Collarole and what fell into Turnover. Collarole is no more than a case which is to be understood as providing coherence through that little bit of jurisprudence. He can't answer the point that reality is on my side as the Commission had submitted, because reality obviously is. If you look at the two pieces of legislation, as we did when I made my earlier submissions to you, they apply at the point of retirement. They're designed to apply at the point of retirement. Judges obviously read them in anticipation of retirement, but they know their rights at the point of retirement. And that's why we say the Commission were right in saying what was the reality of the situation, even though it couldn't be applied for financial reasons when the specific, limited legal certainty, temporal limitation was applied in Barber and that jurisprudence. So we put that to one side and we say that cannot be seen as dispositive of this case for those reasons. He referred to two cases as saying, well, even outside the Barber context, this approach has been maintained. The two cases were Vröger, which is tab 10, and Barch. I only need you to look very shortly at tab 10, and you can see from the catchwords at the top that he's wrong about Vröger. The catchwords at page 311 tell us that this is a case about the Barber Protocol.
Yeah, but they didn't give it apply.
At page 311, at letter G, you'll see the last catchwords, Protocol number 2, annexed to the Treaty on the European Union, that is to say the Barber Protocol, dealing with Article 119. Vröger is of a piece with the earlier jurisprudence. I'm not going to take further time on it. Barch deals with an entirely different set of circumstances to these. It's tab 13 in the second bundle. Barch, you can understand best its relevance to this case, if any, by looking at the operative part of the judgment. Certainly my practice, and I suspect probably yours, to always try and understand a European judgment by reading the operative part first. The operative part is at page 424, and it tells us this. The application which the courts of member states must ensure of the prohibition under community law of discrimination on the ground of age is not mandatory where the allegedly discriminatory treatment contains no link with community law. No such link arises from Article 13, that's the Mangold point, because there's no general principle of non-discrimination on grounds of age which gives rise to enforceable rights, or in circumstances such as those at issue in the main proceedings from Directive 2078, before the time limit allowed to the member state concerned for its transposition has expired. It gives no ruling at all on what is the position after the date for transposition having expired.
Yes, in paragraph 26, they simply find it unnecessary to answer any of the questions to do with temporal effect.
My Lord's ahead of me, but it seems to me the operative part, in a sense, is as sound a foundation for my saying you get no help from Barch. And that really, in a sense, summarizes the response that we make. We stand on our analysis of Paris. We've shown its reference. We don't accept that he can escape the points we make about Lessar simply by saying that there were some special situations there. The overarching point is it was a claim for pension credit, which gave rise to a pension payment in relation to periods of service as an apprentice, that's to say, work and training on the job, which had taken place many, many years beforehand. And nobody took the point in the court, in the Advocate General's opinion, or the parties, to suggest that that period was not subject when it came to the analysis of what the pension credit should be at the point of retirement. Nobody suggested that it was irrelevant because it was in the past, because of the Barber line of jurisprudence. My Lords, my Lady, those I think are the key points in reply. You've heard very quick argument, and we've tried to put as much as possible in writing. The test for you at the end, surely, is whether it's clear that this is out clear against us. If it's not, then it's appropriate to make a reference. We would submit. Everybody's agreed there's a core point of European law. It may intrigue and possibly amuse you to know that Mr. Kavanagh, having lost in front of Employment Judge Macmillan, in his notice of appeal to the Employment Appeal Tribunal, before he'd worked up the turnover point, expressly said that the Employment Appeal Tribunal should make a reference in the notice of appeal. He changed his position when he'd worked up the turnover jurisprudence in the way that you've heard. Now, that doesn't prove anything, but if you have any doubt, let me put it that way, that the turnover jurisprudence can be read over without qualification into this field of law, the Part-Time Workers Directive, then it seems to me a reference has to be made, and the court can advise us accordingly as to how we have to deal with it. We therefore ask for a reference. We've suggested a question. The court will no doubt have its own views about it as to how it should be formulated. Is there any other point I can answer from the court on either side? And will you allow me to just have a quick word to see if I've missed anything?
Just make sure, yes.
Yes.
I'm just wondering,
Not just now.
we could wait until to see what Paris actually says. And I think,
When did you
yes,
It's at the foot of our speaking note.
oh, I suppose we can discuss it ourselves.
Right at the end of the speaking note. Have I given you a wrong version?
No.
I'm so sorry. Yeah. Can I add one final point? I don't think this is a point of fact which will be dispositive in the case, but I do post a query about the accuracy of what my friend has said about contributions to the Consolidated Fund from the Ministry of Justice. We did discuss these issues when looking at the justification for discrimination against judges in the last part of the hearing. And my recollection is it's not as straightforward as he has said. I can certainly say that it has never been argued that there is an issue of financial difficulty that arises from our construction. Nothing equivalent to the arguments put forward by the pension funds in the Barber cases have ever been argued against us in this stage of the argument. I think I'm allowed to sit down, but I'll just look. Thank you, my lady.
Thank you. Thank you. Well, we're grateful for the gallop. It can sometimes make it easier to retain things in one's head. However, your reference to Mr. Kavanagh having to work things up has at least satisfied me that we now have to go and work things up. So we will not be in a position to tell you the outcome of this hearing immediately. So there is no need for you to hang around and hear the outcome. We will let you know in the usual way in due course.
My lady, may I just say that we hadn't seen the draft form of the reference that my learned friend referred to till we received his speaking note at 10:30. So if you were minded to make a reference, we'd be grateful for the opportunity to make submissions on the text.
Yes. Well, what we have tended to do if we do make a reference is to draft it as a reference, which is obviously shorter than a judgment because they only want 10 pages, which is quite a challenge. And then ask counsel not only for their textual and minor corrections, but also for their comments on the proposed question. Thank you. Well, thank you all very much indeed. The court's now adjourned.